So we are with the respected Emmanuel Bright Atoko. He's a lawyer for Twellium Industries Ltd. That's a company that produces alpha cracker and was sued by Nutrifoods Ghana Limited because of similarities which they claim of their wrapper of the King cracker and also alpha cracker. The High Court, that's the General Jurisdiction Division of the High Court, pronounced judgment on the suit of Nutrifoods Ghana Limited on the 18th of December 2023, and we are pleased to discuss the judgment and the effect of same so far as the jurisprudence of trademark law, torts law, of passing off, and also intellectual property is concerned. Mr. Atoko, we are happy to have you.
You're welcome.
Great. So, with respect, what is the effect of the decision?
The effect of the decision is very simple. That patrons or customers of the Alpha Cracker biscuit are free to do so, are free to patronize the biscuit as a different brand of biscuits on the Ghanaian market, distinct from King Cracker biscuits produced by Nutrifoods Ghana Limited. So basically, that is the effect. And also, since the court refused the reliefs being sought by Nutrifoods for the destruction of all the units on the market, the units of Alpha Cracker on the market, that relief has also been refused. Once it has been refused, it means that the destruction cannot be carried out, and the relief for injunction also cannot be sustained. So basically, these are the effects of the decision on the ordinary consumer of Alpha Cracker biscuit produced by Twellium Industries Ltd.
We do reckon, and we've all carried a story on the injunction application by Twellium this time around against Nutrifoods. That's why we title this whole saga and matter the Biscuit Wars. So the contention will be, as lawyers, as legal analysts, will be that given the decision in this matter, that is Nutrifoods Ghana versus Twellium,
Yes.
then the decision in Twellium versus Nutrifoods Ghana,
Yes,
may follow the same thinking, thoughts, and outcome as we have in the 18th December 2023 decision, which we are discussing now. Would such a person or thought or thinking be accurate?
You know, since the matter is still pending before the court, and by professional ethics, we cannot comment on a subsisting or a pending case. So I cannot say that this decision, the current decision, which is in respect of Alpha Cracker biscuit, will have a bearing on the breakfast cereal biscuit that is still pending before the court. Now, I must say that the ruling that came earlier on the breakfast cereal biscuit was an injunction application. But it appears some people confuse it with as if it was a judgment. It was not a final judgment. It was an application for injunction. So the substantive matter is still pending before the court and yet to be determined.
Interesting. With respect, now we zoom into the general effects and insights the decision brings to trademark law. It brings to the whole umbrella subject area of intellectual property and also torts laws as regards passing off.
Yeah.
From where you sit, what is the effect?
Okay. There are two main issues or two broad concerns about this judgment. To me, I see the judgment as one, advancing the frontiers of our intellectual property law jurisprudence, which in fact has not been so much elaborate because we are not so much into industrialization. See, so if there is industrialization and there is competition between companies producing similar goods, the likelihood of imitation will be high, and that would actually result in litigation. But unfortunately, our nation, we are yet to get to that level. In other parts of the world, in fact, if you look at the extensive research we did in our addresses, which my lord the judge commended us on, you would see we went to other jurisdictions where these issues are not rare. They are issues of common occurrence. But in our country, we don't have such things. So we see this decision as actually advancing the frontiers of IP law. And I think it also reawakens some sense of consumer protection. So the consumer becomes aware that this product is an imitation, or this one is not an imitation. As the court rightly decided on the Alpha Cracker biscuit as not an imitation of King Cracker biscuit, the consumer knows that there is a distinction. So a consumer who is interested in purchasing either products knows what he is buying. Secondly, the decision also comes to advance the frontiers of our law of evidence. The law of evidence, or let me say the entirety of what we do as lawyers, largely in court, is on the rule-based evidence, which we have rendered into Latin is a re incumbit probatio. He who alleges must prove. Now, on the rule of evidence, you can see that in the judgment, an allegation was made of a confusion on the market as a result of the introduction of Alpha Cracker biscuit. Once that allegation was made, it was incumbent on the one who made the allegation to adduce cogent and sufficient evidence in proof of the allegation, which the court in this case found that Nutrifoods was unable to do, especially when the case was premised on alleged complaints from consumers, distributors of Nutrifoods, that there is a particular product that is Alpha Cracker biscuit on the market, creating confusion. In such circumstance, the law requires that you introduce evidence to support your claim. Once you fail to do that, certainly there can be not. It is a bare assertion, and we know the court never depends on bare assertions to grant a relief. The court depends on evidence. What evidence do you have? In fact, in the course of our research, we came across a case where the manufacturer, who is the plaintiff in the case, had to go and call even trotro drivers, taxi drivers, to come and testify as to whether there is confusion in the market between their product and the product of the defendant. You see, so it is not just something you just sit down and come to court and say that, look, I have this product, there is confusion being introduced as a result of the introduction of another listing. The law permits competition, and competition is healthy for consumer protection. All this is to ensure that the consumer is protected. You and myself, we are consumers of the product. So if there's a fake one, we should be able to know which one is fake and which one is the genuine one. from what the decision states, both products are genuine. They are just distinct. So I think, in a nutshell, this judgment has come to advance, one, the frontiers of our IP law. Two, it has also come to cement or add to the rule-based litigation, which states that there must be evidence of whatever you say. Before I end on that, I think when you look at the Act, that is Act 589,
That's
the unfair. Let me just put it, Unfair Competition Act.
Yes.
Okay.
So that act essentially is to ensure that competition between players of the market is fair.
It's fair. It's fair. And because it wants fairness, it also says that even when there is the likelihood of confusion, so it's not just the confusion existing, the likelihood of confusion, even the party who is likely to be affected can go for a restraining order. So it's not limited to only
Actual confusion.
exactly. You understand? And also it also looks at your reputation or goodwill being damaged. If you are into industrial activity, you are into commercial activity, and you feel that your business or enterprise is likely to be affected or is likely to be damaged by a product that has just been introduced onto the market, you can proceed to court for a restraining order for against the person who is introducing the product. In fact, even it talks about even celebrities in this age and era where we have
Social media.
and then we have slay queens. I'm sure we very soon have slay kings. So if you are known by a particular hashtag, let me put it that way, and somebody wants to copy that which is identified with you, you can go for a restraining order against that person. That was not this case, because clearly, if you take Alpha Cracker Biscuit and you take King Cracker Biscuit, you can see the remarkable distinct features. You can clearly see. We see the court looks at the ordinary man. How will the ordinary man perceive the product? It's not about having maybe some industrial knowledge or having some expertise. No. The ordinary man sitting in a trotro van from Accra to Medina, how would he perceive the two products? Will he see them as the same? If you will see them as the same, then there is the likelihood of confusion. But if you see them as distinct, then certainly they are distinct products.
In this modern day and era, if I may add, or if I may bounce off you, would you also add the concept of the decision enforcing, strengthening competition?
That is so.
It strengthens competition.
That is so.
Yeah, because I do have a friend who is called Shafiq.
Okay.
A brilliant lawyer who is always drumming it on social media that we should have anti-competition laws.
Okay.
You know, because it appears, as the judge did arrive, that they were just the plaintiffs were just afraid of competition.
Exactly. That is so.
All right. So, Mr. Atuko, we are grateful for your time.
Welcome. You are most welcome.